90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My special guest is attorney Ruth Kraft, and she's the chair of the Employment and Labor Law Group at the law firm Falcon, Rappaport, and Berkman, with offices on Long Island and New York City. We're going to focus on who is considered an employee versus an independent contractor, and what that means for the worker and for the company or the employer. Ruth, welcome to Law You Should Know.
Thank you so much, Ken, for having me. I'm delighted to be with you today.
And I know that these are issues you're going to discuss, that you represent employers and you try to keep them on avoiding consequences. And some of what they do has consequences for the employees or the independent contractors. And we'd like to touch on those things as well.
Absolutely. And I began my involvement in this as a judge, hearing misclassification cases.
And especially as we emerge from COVID and people have all kinds of alternate arrangements and second jobs and different gigs and part-time jobs, it's become a more complicated world for both the employer and the employee or the gig worker. So let's talk about the classification system and what is misclassification.
Okay, so misclassification is when an individual who should be considered an employee in covered employment is labeled, or we should say mislabeled, as an independent contractor. And obviously, someone who is an independent contractor would not be available for benefits of employment, withholding taxes, vacation, health insurance, and a myriad of other benefits. And that can be really problematic.
And there also might be legal liability if there are some physical or other legal issues that arise.
Absolutely. And if someone is an employee and they're injured on the job, we have a very extensive workers' comp system to cover that. If they're not employees, then we have an absence of workers' comp insurance. And just to put this in perspective, the penalty to an employer for not maintaining workers' comp insurance is $1,000 per week.
And there also could be tax consequences, for better or for worse, with the IRS and other issues such as workers' comp and other. It's a very complicated thing that an employer and a gig worker should seek the advice of their legal and perhaps their financial
That's
counsel.
Absolutely correct. And so what happens if someone is misclassified is that the employer doesn't have to pay its share of the FICA, the Medicare, and the Social Security taxes.
And even for workers' comp insurance.
And and if you underclassify the number of workers, your workers' comp premium is going to be much lower, particularly in industries such as construction, where the cost of comp is very high.
And workers' comp can provide some legal protections for the worker, but if they're not a worker, they might expose themselves to a variety of liabilities.
Well, what actually happens if somebody is not a worker is that they will report that something did happen at work, and the workers' comp board will investigate. And if they conclude that that individual is a worker, that employer, absent the insurance, is going to be fined tremendously.
And they also may have liability.
Oh, my God.
And perhaps not have insurance coverage for the liability.
Well, yes, but what really happens here is that the employer gets nailed for these enormous penalties and fines that the board will order payment. There's something called the Uninsured Workers Fund. So if it really is determined to happen at work, there will be responsibility through our workers' comp system, which I don't know if you know, was the first workers' comp system in the United States, created by Teddy Roosevelt.
And again, for our listeners out there, whether you're an employee, a gig worker, or an injured worker, these are very complicated issues with very important consequences. So if you have a claim where you need to defend yourself, you must contact appropriate experienced counsel.
Definitely. We're going to be speaking generally about the system, but not individual legal advice.
And if you're an employer caught in the wild west and you don't have insurance to cover you, insurance covers financial exposure and also the cost of defense counsel, so you may have to pay for that on your own.
Not necessarily covered. For example, if someone is misclassified as an independent contractor, and then there is a lawsuit, and we're seeing a proliferation of class action litigation brought on the basis of misclassification, what then happens is that even if you have some form of coverage that might pay some legal expenses, wage hour litigation costs are never covered by insurance. And we have liquidated damages, punitive damages. The employer is responsible in a verdict for the plaintiff's legal fees. I can't even begin to tell you how many class actions I represent employers in now.
And I just want to say in summary, it may seem simple, it may seem convenient, it may seem like you can get away with it, whichever end you're on, but there are important legal and financial consequences,
yes.
And you should think about them carefully, whether you're the employer or the worker.
And let me tell you what makes this really complicated. There was basically, for a century, we basically knew who was an employee and who was an independent contractor. And that was, binary. It was one or the other. Now, the ecosystem of the gig, as you noted, has created this gray area in between. What's a freelancer? Is somebody a freelancer by choice, or are they a freelancer by force?
And this has come up in cases involving Uber drivers,
yes,
and other gig workers or part-time workers or occasional workers. And these things are getting resolved by different states differently. And it's important to protect yourself, whether you're an employee or a worker.
So what is so important to recognize here, when you commented about the states versus the federal, we see a multitude of these suits being brought in federal court. Others are brought in the state system. The statute of limitations in New York is 6 years long. For breach of contract and for employment cases. So the potential liability for an employer is massive over that time period. We are also seeing scenarios in which the law has changed, and this is what I mean. For example, in California, we actually have a relatively new law, AB 5, which makes almost everyone an employee under the law. An employer which has believed that it has conducted itself appropriately under the law can discover that there are changes in interpretation that render them liable ex post facto.
And that's why it's important to have a legal checkup with your
totally.
If you're employees and things are evolving, maybe the nature and the amount of your workers involving, your relations with your employees are evolving. Have a checkup with your labor law counsel.
That's right. And it's really important to have counsel, because I see all the time where people come to me and said, well, I believed that I was doing it right, and now it turns out under the case law that it's not correct. Or this is another classic. Someone starts a new business, a small business. They don't have the money, the resources to hire employment law counsel from the beginning, and they engage in practices that they rationalize as being okay. I'll make somebody a flat rate worker as opposed to an hourly worker, which is another form of misclassification. Or I'll pay them off the books. I won't buy the proper workers' comp insurance. And then suddenly you go from being a one-man show to having 20 workers under a rubric that is improper. And this is the other important thing. People need to know that more than 10 years ago, New York State, the different agencies, the Workers' Comp Board, Unemployment, Disability Benefits Bureau, Department of Labor, U.S. Department of Labor, and the IRS, and the New York Department of Taxation and Finance formed a memorandum of understanding. And so now if there's a workers' comp claim and uninsured, it will be referred for audit to the Department of Labor and to other agencies. So you can wind up with this enormous whammy where you're being investigated by multiple agencies.
And I know this is only the tip of the iceberg out there, and there are many, many issues to cover. Are there any other issues you wanted to mention under the old IRS 20.6?
Yeah, so this is, I think, where people kind of get in trouble. What's employment? Under federal law, the Fair Labor Standards Act says that employment is to suffer or permit to work. There's a very, very broad description. By the way, Ken, did you know that up to 30% of employers misclassify their workers as independent contractors?
And this might include law firms, too.
Absolutely.
Depending on the relationship. So what's the definition of a true independent contractor?
It's very limited these days. First of all, it depends on your state standard, as you so
and let's talk about New
point
York.
out.
Yes.
In New York, we look at a set of standards, modern interpretation, so that 20-point standard, even the IRS has repudiated it. We look at 3 types of control: behavioral control over the activities of the employee, financial control, and then we look at the relationship of the parties. At this point in time, if we have a true independent contractor relationship, one of the most crucial things is, do we have a B2B relationship? And then if we look at that business, is it incorporated? Does it have a tax ID number? What is the nature of this relationship? If it's an ongoing relationship as opposed to an isolated relationship, and also, is it integral to the services of that business itself?
Are the relationships and the assignment, how jobs are passed along, part of defining the relationship?
Absolutely.
And the right to refuse it or turn down?
Yes, that's definitely one of the factors. Let me give you an example here. The classic case in New York, which goes back to 1981, is called Concourse Ophthalmology. And in that, we had part-time ophthalmologists. So first of all, whether you're part-time or full-time doesn't go to the essence of whether you're classified properly or improperly. In that case, these ophthalmologists and optometrists, the company set the fees. The company's premises were used. The company did the billing. They scheduled. They collected. They didn't have control over how the ophthalmologist made determinations. Do you need glasses or not? But about all the operational issues.
And in terms of the fees, they're telling the worker what we're paying you, as opposed to the worker saying, this is my rate.
One of the things I look toward is whether there's been a negotiation in good faith about the fee. Also, how is that fee being paid? Covered employment, if you were a manual worker under the Fair Labor Standards Act, you must be paid every single week. That is a brand new area with huge amount of litigation now, that if you pay bi-weekly, which many companies do, and you have a manual worker, including, for example, a hairdresser, there is now new class action litigations in which the penalty for not paying week number 1 at the end of 1 is a full extra week of compensation.
Right. That's a whole other issue, the rights and responsibilities of employers. I'd just like to remind our listeners, we're talking about employment law and you, whether you're an employee or independent contractor, and the consequences for both parties. Our guest is Ruth Kraft. She's the chair of the Employment and Labor Law Department of Falcon, Rappaport, and Berkman, and they have offices on Long Island and in New York City. As you've heard, this is a very complicated area, and I want to remind our listeners, you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island. If you missed any portion of this program or you want to tell someone else about it, just go to the podcast at nccradio.org. And there's many other podcasts about the law at that site. So on the flip side, someone can be a part-time employee.
Yes.
That may be the happy medium, because a person works a day or a couple hours on a occasional basis, or maybe perhaps once or twice a week for a certain employer, and they follow those rules of authority that you mentioned.
That's right. And
so someone can be a part-time employee, and that may be work, and that may be legal, and keep both parties
what happens is some employers will say, well, if you have the ability to work for somebody else, doesn't that make you an independent contractor? And the answer is, we would look at each of these relationships to assess whether there's independence. For example, very importantly, has this individual invested in his own or her own equipment or supplies? If I'm using the employer's supplies and I'm working out of that employer's physical premises, the likelihood is very high that that is covered employment. And we also look at, for example, does this individual exercise independent business judgment? Can they Do they have any considerations as to the ability to create profit and also to incur loss? If you are not taking the risk of loss, and in your particular business, whether incorporated or not, you are an employee.
What about acceptance versus rejection of the product, whether it's a brief or a cabinet or a home improvement job?
So one of the important factors, and again, there were so many factors, and you look at them and not one factor is determinative. This is the most confusing thing. In the old IRS standard, we would look at the 21 points and we would say, 20 points, did we get to 11, right? Now we don't do that. All the factors can be evaluated. Some can be more equal than others under a given circumstance. And that is what gives the state, the regulators, the ability to try to make these judgment calls that an employer, putative employer we call them, may not have necessitated or expected. So we look at not just the outcome of the work, but control of the performance, not the result, as being an important factor.
And that's true whether you're a lawyer or a mason or anything in between.
Yeah, well, in general, now that you mentioned masons, thank you, there are special laws regarding individuals in certain occupations. The concern with the masons being independent contractors was, what if they're injured on the job and there's no workers' comp insurance? So we have pretty strict labor law protections for them that find that someone who's a mason, unless he's the owner of the business, is going to be an employee. Believe it or not, since we're in a radio studio, there is a special labor law in New York State that says that if you were involved in the performing arts, television, radio, the theater, the ballet, anything relating to that, those must be employees. A film editor who might be working from home under our statute is a covered employee. And I've represented film companies, independent film operators, who did not realize that they could allow someone to work on their own equipment, on their own time, but yet by statute, those must be employees.
And that includes the ability to be hired or fired. No matter how big you are, if you're an employee, you can be fired.
Well, if you are in your own business and an independent contractor, then what we're really doing is terminating a contractual relationship, as opposed to when we say be fired. If somebody is fired and it's not for good cause under the unemployment laws, they are eligible to collect unemployment. And the way many companies get caught is that individual files for unemployment and the state discovers that there haven't been tax filings attributable to that person.
And there also could be discrimination issues that come into play if you're an employee and an employee, as opposed to a contractor.
I'm going to tell you that for the purpose of the discrimination laws right now, that if somebody is a contractor and they say that they were exposed to discrimination, harassment, now the sexual harassment cases, they can still sue, because a public accommodation under the civil rights laws, under Title VII, you can sue and claim that public entity, and I should say not public entity in the nature of a governmental agency, is in violation if they knew or should have known of the conduct. And the sexual harassment laws and the discrimination laws are beyond what we're going to talk about today. We could spend hours discussing them, but it's not an absolute defense.
And I'm sure you lecture your employer clients on the best practices to avoid all these problems.
100%. And New York State, quite a few years ago, passed a law requiring every employer to train every worker in every calendar year about anti-harassment and anti-discrimination. And we train on that at the firm. There are larger companies in unique industries for which I have created training modules and lectured. Otherwise, if you are a small business person, know that the Commissioner of Labor in New York has a video online. It is free. And then the quiz, and every employee should take that, and it should be in their employee's file.
I just want to go back to the gig economy. How does that play into all this? What are some trends? What do you think will happen in the future?
With great difficulty, to be honest. So when I talked about that freelance by choice, freelance by force, these are the leading cases now influencing who is entitled to protections under the employment law. And it's really interesting. David Weil was President Obama's wage hour czar. He talks about our current state of the economy as being fissured. right? Because he says some jobs have been offloaded onto platforms as the result of technology. Of course, Uber, Lyft, Instacart, Grubhub. And the consequence is this has generated enormous litigation. The cases are going on all over the country.
And one reason is when people are laid off, when people get sick, they want the benefits of being an employee. That gig sounds wonderful in the beginning, at least for the worker, but then they realize it's like they're a small business owner and they have a gig. Companies
like Uber and Lyft have been involved in litigation for years about that. I was actually reading one of the Grubhub cases out of California last night because of a case I'm involved in. The case is going on for over 8 years in the Northern District of California. We actually see various results where the federal court in California will issue one result and the state Supreme Court will issue the opposite result.
And state laws may vary, and the liberalism of state courts may vary, as well as interpreting those laws.
Not only that, but let's face it, in today's economy, we have a multi-state economy. Our own HR director lives in North Carolina at the firm. It's now very common for people to live in one state and work remotely.
And these gig economies involve millions of people.
Millions. Countless millions of people.
And it's a significant part of our economy, and companies have their business model based on those gig workers.
And we have, the ecosystem of the gig has a whole variety of relationships. What happens in the litigation is that we don't have hard and fast rules. We have to look at each individual relationship of the putative employee-employer and determine whether that is covered employment or not. And the consequence of this is it's a bonanza, to be honest with you, for lawyers on both sides. But it's very frustrating because we do not have certainty. I wrote an article on LinkedIn about this, and I called it Flip-Flop Nation, because not only, did we have a sense of what the employment laws were like, and it's like building on quicksand, frankly, but a lot of the administrative agencies that have the obligation to evaluate these, they flip-flop based upon which political party is involved and controls.
And also what their constituents, business or individuals want. I'd just like to remind our listeners, we're talking with attorney Ruth Kraft. She's the chair of the Employment and Labor Law Group at Falcon, Rappaport, and Berkman, with offices on Long Island and New York City. And Ruth, can you tell us your firm's website where they might find some of your blogs and other information about this area?
The firm's website is F as in Frank, R as in Robert, B as in boy, law.com. We have a bunch of articles that are on the website, not just employment law, but many other fields of law as well, and burgeoning new areas of law, including crypto and all sorts of stuff over there. Lots of tax articles, bankruptcy, interesting stuff, I would say. We're a full-service boutique law firm.
And as we emerge from COVID and people maybe return to the workforce or maybe withdraw from the workforce and looking for gigs so they can physically stay close to the home or have more flexible hours as we emerge from COVID, what are some of the issues that will emerge? What issues should employers and workers try to learn about before they enter into a relationship? Just very briefly.
I was going to say I can talk for hours about this. So one of the issues is the multi-state issue. AB 5, the California law, we do not yet have definitive case law whether if a California company hires somebody who lives in another state that doesn't have as restrictive an interpretation of employment, what's going to happen. Another big issue, if you work from home, you mentioned workers' comp. What are the conditions in that home workspace? Is it ergonomic? This goes on and on.
Is it partly ownership of equipment? Who controls the hours? Who controls the work load? Who says the work is okay? Who has to approve it?
It's a whole variety of things if you have control. But if you assume that something is covered employment, then we have all the ergonomic issues, the liability issues. What do we have? Disparate treatment issues? Can you work from home perhaps and not me?
So is a worker better off being a traditional worker? Is an employer better off having traditional employees?
Well, I think that it honestly depends on the industry. In most cases, the trend now in Washington is to consider a much larger group of people to be in covered employment. And you must remember one important thing. When people are in covered employment, they are very well likely to be eligible for unionization. Independent contractors generally cannot unionize. That is one of the things in this gig economy issue with Uber and Lyft, Amazon.com, that people, if they form or enter into collective bargaining agreements, they believe that they have more power. And unfortunately, we are seeing employers who are fighting on the independent contractor front, not just because of the benefits, but because they fear unionization.
And let's talk about lawyers as employees. Are they better off being an independent contractor, charging maybe more per hour, but having less job security or benefits?
Well, I don't know that lawyers have job security because we're typically not contract workers. I happen to be a partner, so that's a little bit different. I think that most lawyers, you can debate, we're getting into gray areas, what is an of-counsel relationship. You have to really look at that individual lawyer's practice. If you practice collaboratively, then I think being in a firm has tremendous advantages in terms of serving the client and being able to bounce things off of other people.
But I'm just saying, as an employee, you may get a paycheck, paycheck every week. If you're of counsel or an independent contractor working from time to time, you may not have those guarantees.
You may not have that, but if you hit it big on a case as a plaintiff's lawyer, you could have a real bonanza of a payday. And then you take the risk that when things are slow, or if you are unsuccessful in litigation, that you're going dry.
To protect all parties, should there be an agreement in writing about the status, about the compensation, about bonuses, overhead, things along that line?
Absolutely. And I want to say one thing about these agreements, because I not only write them, but I have the misfortune of reading some that are poorly written. My classic is when you see a contract between one business and another, and the heading says independent contractor agreement. And on page 1, the first clause is, this is an independent contractor agreement. I will tell you, when I was a judge, that was the red flag that something wasn't right. Because if you and I are having a business relationship, what are we going to talk about? All the things you mentioned. We're going to talk about the terms and conditions, what your expectations of my performance are.
It's a two-way street.
That's absolutely right.
If the employer's saying it's my way or the highway and these are my 20 terms, they are an employer and you're the employee.
Well, it depends. I mean, we'd have to go into the individual circumstances here, but my concern is that contracts should be written to reflect a bargained for, good faith business relationship. And if you read a contract that doesn't include that, here's my classic. You read a contract, it says you're an independent contractor, payment by the hour. That smells. Okay, if I can control the steps of the process, not just the outcome, and this is stipulated in the contract, that's going to be employment.
What about the methods or the right of approval?
The right of approval of the process and not of the outcome is highly indicative of covered employment.
Okay, as you said, there's a very complicated area. There's more information available on your website, FRBlaw.com. I'd like to thank our guest, Ruth Kraft, of the firm of Falcon, Rappaport, and Berkman, for being our guest on Law You Should Know. As you've heard, it's a very complicated area. Whatever you've heard is presented as information only. You can only get legal advice from your own attorney based on the facts of your unique situation. If you want to listen to the podcast again or tell someone else about it, go to nccradio.org, and please join us next week at this time on 90.3 WHPC for another episode of Law You Should Know.